This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And welcome to episode 21 of Constitutional Law. Today, we're tackling the Sixth Amendment.
That's right, a really crucial one for anyone dealing with criminal procedure. It lays out some fundamental rights.
Absolutely. And just a quick reminder for everyone listening, whether you're new or have been with us for a while.
We are AI bots.
Yep. Brought to life by, well, AI magic, and critically, Angela's fantastic constitutional law notes.
Our job really is to try and make this mountain of legal information a bit more digestible.
Especially for you folks deep in bar prep right now. We know what that's like.
What we know through Angela's experiences, I suppose.
Yeah.
And speaking of Angela, we really have to mention the brains behind all this.
We do. Angela's a law student over at George Mason University.
She has this really interesting background. She's actually a dual American and British citizen.
Yeah, that's pretty unique.
It is. And she went to law school in both the U.S. and the U.K.
Wow, okay. So she's seen law from a couple of different angles.
Exactly. That comparative perspective really adds something. You know, it enriches the notes we use, gives them a depth they might not otherwise have. She's definitely the brains behind this podcast.
No doubt about it. And hey, if you want to get in touch with Angela, maybe ask a question about the podcast or suggest a topic, you can email her. The address is podcast@studyforthebarinyourcar.com.
Right, podcast@studyforthebarinyourcar.com.
She really does appreciate the feedback. Helps make these better for you.
And there's something else, too.
Yeah.
Angela also works as a freelance remote law clerk.
That's right. So if you happen to be an attorney listening, or maybe you know one who needs a hand with, say, legal research or drafting motions.
Angela's available for that kind of work. She's got the skills, definitely.
Absolutely. Deep legal understanding, rigorous training. She's a great resource.
So for professional stuff like that, the email's different. It's hello@legalwriterandlawclerk.com.
Got it. hello@legalwriterandlawclerk.com.
Okay, so the elephant in the room for so many of you listening right now.
Uh-oh.
The bar exam.
Yeah.
It's looming, isn't it? Coming up very soon.
It really is. You're probably, knee-deep? Neck-deep in outlines and practice questions.
Totally. It's this massive thing, this career-defining hurdle. And it brings up that question. How do we feel? How do you feel?
Yeah, that's the big one. Are we ready for it? Are you ready?
I mean, honestly, can you ever feel totally ready for something like that? A high-stakes exam with so much writing on it.
That's such a good point, that feeling of maybe not being quite ready. It's almost universal, I think.
Yeah. You study for months, you pour everything into it.
Right. Hours and hours. You're trying to absorb just the sheer volume of information. Federal law, state law, rules, exceptions.
It's exceptions to the exceptions.
Exactly. And then you have to recall it, apply it, all under intense time pressure.
It's not just knowing it, is it? It's performing under pressure.
Precisely. Can you spot the issue in that tangled fact pattern? Can you write a coherent essay when the clock's ticking down? It tests everything. Your knowledge, your analytical skills, your endurance, even just your ability to manage stress.
And that anxiety.
Yeah.
It's natural. It's a product of how much it means and how hard it is.
So true. You dedicate so much time. It's not just memorization, though there's plenty of that.
Oh, definitely lots of memorizing black letter law.
But it's more, right, it's internalizing it, making it part of how you think, so you can apply it almost instinctively.
Yeah, you need to be able to pivot to see the connections between different areas, like how con law principles might pop up in a crim pro question, or vice versa.
It's about synthesis, taking all these pieces and building a coherent legal argument.
And that's why you do so many practice questions, right? MBEs, essays, MPTs.
God, yes. The endless practice.
It's not just about getting the right answer. It's understanding why it's right and why the wrong answers are wrong. That's where the real learning happens, I think.
That iterative process, reviewing, refining, understanding the nuances, that builds confidence, even if that totally ready feeling never quite arrives.
It's like training for a marathon, maybe. You put in the miles, you prepare, but race day is still race day. You just have to trust your training.
Good analogy. And con law itself is such a marathon topic. Separation of powers, federalism, individual rights. Big, big concepts.
Huge concepts. But then you also need the granular details of specific amendments, specific cases. It's that constant zoom in, zoom out.
Keeping both the forest and the trees in view at the same time.
Exactly. And that's kind of what we try to help with here. Distill things down, focus on the key stuff from Angela's notes.
Right. Give you those core insights you need for the bar.
So with that, should we dive into today's main event?
Let's do it. The Sixth Amendment.
Okay.
So yeah, our main focus today, The Sixth Amendment to the U.S. Constitution. This is really a pillar of American criminal procedure.
Absolutely fundamental.
Yeah.
It guarantees a whole set of rights if you're accused of a crime.
And, when you first read it, it might seem, I don't know, fairly clear.
Perhaps. But like so much in law, the deeper you go.
The more complex it gets, the nuances, the court interpretations, the case law, it gets very rich very quickly.
Exactly. So to really get a handle on it, the best place to start is always the text itself.
Agreed. Let's read it out word for word.
Okay. The Sixth Amendment says, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense."
Right. That's the black letter law, straight from the source, the foundation.
The bedrock, as you said earlier.
Now, the plan for this part of the podcast is to really tutor you, our listeners, prepping for the bar, on the key concepts here.
And we're drawing directly from Angela's outlines, her law school notes. They really distill what you need.
Okay, so let's get into those rights. One of the biggest ones, maybe the most well-known, is the right to counsel.
Yes, the assistance of counsel for his defense. This is huge. It's not just about having a lawyer nearby.
It's about having effective assistance, right? Someone competent representing you.
Precisely. It's a crucial safeguard. Now, Angela's notes cover this, but here's where we need to be clear about scope.
Okay, what's the clarification?
Well, the original plan, the outline we had, suggested we go really deep into all the specifics. When the right automatically attaches, how it applies during critical stages, the rules against deliberate elicitation once it attaches, the requirements for waiving the right.
Right, all those detailed subtopics that are definitely tested, like Messiah violations and stuff like that.
Exactly. And also its non-applicability to non-critical stages, like pre-charge lineups and the specifics of the exclusionary rule for Sixth Amendment violations. Really getting into the weeds.
Okay.
So here's the important point. Angela's notes, which are the only source material we use for this podcast to ensure accuracy.
Right, we stick strictly to her notes.
They provide a great overview and cover the core principles, like the text itself and incorporation, which we will discuss. But they don't contain the really in-depth, specific legal explanations, the detailed case law analysis, or the fine-grained nuances for all of those individual subtopics I just listed.
Ah, I see. So the provided notes don't go into that level of detail on things like, say, exactly which post-charge interactions count as deliberate elicitation under specific case precedents.
Correct. Or the precise factors a court weighs for a knowing and voluntary waiver beyond the general standard. The notes cover the existence of these concepts, but not the extensive deep dive into the case law surrounding each one.
Okay, so that's a limitation of the source material we have for this particular amendment. It's not us choosing to skip it.
Exactly. We want to be upfront about that. We can't provide that level of detailed discussion on every single point because it's simply not in the notes we're working from for this topic.
Understood. So what we can do is cover the foundational text, the general principles that are in the notes, like the basic right to counsel concept and incorporation.
Yes. We can lay that groundwork solidly based on Angela's outline, but for that really granular analysis of each specific doctrine and the associated case law.
You, the listener, will need to rely on your comprehensive bar prep materials, your case books, commercial outlines, practice questions for that deeper layer.
Precisely. Think of this as reinforcing the main structure and highlighting key areas from Angela's perspective, but not the exhaustive treatise on every nuance.
Got it. Good to clarify.
Yeah.
So let's talk about what Angela's notes do cover regarding the right to counsel, the general principle.
Okay. So the fundamental idea, assistance of counsel. It's there to ensure a fair trial in the adversarial system.
Makes sense. You need someone who knows the rules navigating the process. Now, when does this right actually kick in, formally?
That's a critical point the notes do address. The automatic attachment happens after formal charging.
After charging, not upon arrest.
Correct. It's triggered once formal adversarial judicial proceedings have started. That could be an indictment, an information, an arraignment, a preliminary hearing. Basically when the state has committed itself to prosecute.
Okay, that's a bright line, more or less. Indictment or equivalent, Sixth Amendment right to counsel attaches for that specific crime.
Right. And once it attaches for that crime, the notes highlight a key consequence. The government can't deliberately try to get incriminating statements from the defendant about that charge without counsel present.
This is the Messiah rule principle, generally speaking, even if they're not formally interrogating.
Yes, the principle against deliberate elicitation, using an undercover agent, a jailhouse informant acting for the government. If the purpose is to get the defendant talking about the charged offense after the right is attached, that's generally a violation.
So the government can't sneak around the lawyer once the formal process starts.
That's the gist of it, based on the notes. Now, can the defendant give up this right?
Can they waive it? I imagine so, but it must be difficult. Or have strict rules.
Very strict rules. The notes emphasize it has to be knowing and voluntary.
Knowing and voluntary. What does that mean in practice, based on the outline?
Knowing means the defendant has to understand what the right is and the risks of going without a lawyer, the dangers of self-representation.
Okay. They need to be warned, basically.
Yes, usually by the judge in a direct conversation, a colloquy. And voluntary means no coercion, no tricks from the government to get them to waive counsel. It has to be their clear choice.
A high standard, as it should be for such a core right. Now, you mentioned earlier that the right applies during critical stages. What does that mean?
Right. The notes explain this concept. A critical stage is any point in the prosecution, after charging, where the defendant's rights could be seriously affected and where having a lawyer could make a real difference.
So things like the trial itself, obviously.
Obviously the trial, but also things like post-indictment lineups, preliminary hearings, arraignments, plea negotiations, times when legal skill and advice are crucial.
And conversely, there are stages where it doesn't apply. Non-critical stages.
Yes. The notes point out its non-applicability mainly before formal charging.
Like those pre-charge identifications. A photo array shown to a witness right after a crime.
Exactly. The Sixth Amendment right hasn't attached yet, so it doesn't apply to that pre-charge, photo array, or lineup. Other rights might, like due process if it's overly suggestive, but not the Sixth Amendment right to counsel.
Okay. And what about after conviction, like appeals?
Generally, the Sixth Amendment right to counsel, as outlined in the notes, applies to the first appeal as of right. But discretionary appeals, or later things like habeas corpus, those usually aren't considered part of the original criminal prosecution covered by the Sixth.
Got it. So what happens if one of these Sixth Amendment rights is violated? Say, police deliberately elicit a statement after charging without counsel or waiver. What's the remedy?
The main remedy discussed in the notes is the exclusionary rule.
So the evidence gets thrown out.
Generally, yes. Evidence obtained in direct violation of the Sixth Amendment right to counsel, like that illegally elicited statement, is inadmissible in the prosecution's case in chief.
To deter violations and protect the right.
That's the idea. Though, like other exclusionary rules, there might be exceptions, like maybe using this statement for impeachment if the defendant testifies differently at trial. But the core rule is exclusion from the main case.
Okay, that covers the main aspects of the right to counsel as presented in Angela's notes, acknowledging the limits on the depth of detail. Now, what about applying all this to the states?
Yes. Incorporation. This is fundamental con law stuff.
Because the Bill of Rights originally just applied to the federal government, right?
Correct. So how do rights like the Sixth Amendment protect you against state or local police or in state court?
The 14th Amendment.
Exactly. Specifically, the Due Process Clause of the 14th Amendment. The Supreme Court, over many decades, used this clause to say that certain rights in the Bill of Rights are so fundamental.
So essential to liberty and justice.
That they must apply to the states, too. This process is called selective incorporation.
Selective because not everything got incorporated, or not all at once.
Right. And Angela's notes reference this general principle, citing a source mentioning that the court incorporates amendments if they are fundamental, and that only a few provisions remain unincorporated today.
So how does this apply to the Sixth Amendment specifically? Has it been incorporated against the states?
Yes, the notes make it clear that the Sixth Amendment has been partially incorporated. Most of its key provisions do apply to the states through the 14th Amendment.
Most. So like the right to counsel we just discussed, speedy trial, public trial, confronting witnesses?
Yes, all those core rights, counsel, speedy trial, public trial, jury trial in general, notice, confrontation, compulsory process, those have been incorporated and apply fully to state criminal proceedings.
Okay, that's the majority of it. But you said partially incorporated. What parts weren't? This sounds like prime bar exam fodder.
It definitely is.
Wrong.
Angela's notes specifically highlight a couple of aspects related to the jury trial right that were not incorporated.
Oh, right. What are they?
First, remember the text says, jury of the state and district wherein the crime shall have been committed.
Uh-huh. Sounds like the jury needs to come from the specific place the crime happened.
Well, the part about the jury being from the state is incorporated, but the specific requirement of being from the federal judicial district where the crime occurred, that was not incorporated against the states.
Ah, okay. So states have more flexibility in defining the geographical area from which they draw juries. They don't have to follow the federal district lines precisely.
Correct. They still need an impartial jury from the vicinity generally, but not necessarily that specific federal district.
Interesting nuance. What else wasn't incorporated?
The other key point from the notes relates to the nature of the jury itself. Traditionally, federal criminal juries have 12 members and must reach a unanimous verdict.
Right, the classic image of a jury.
But the Supreme Court held that the requirement for a unanimous 12-person jury in a criminal case was not incorporated against the states.
Really? So state juries can be different?
Yes. The court has allowed state juries to be as small as 6 members in non-capital felony cases. And for a time, they even allowed non-unanimous verdicts in some state criminal cases, although recent rulings have pushed back toward unanimity being required even in state courts for serious crimes. But the key takeaway from the notes for incorporation purposes is that the traditional 12-person unanimous federal standard wasn't fully imposed on the states via the 6th and 14th Amendments.
Wow. Okay, those are really important distinctions. The non-incorporation of the specific district requirement and the non-incorporation of the mandatory 12-person unanimous jury standard for states.
Exactly. Knowing what is incorporated, most of the rights, and what specifically isn't, those jury details, is crucial. It highlights that selective incorporation is, well, selective.
Definitely something to flag in your own study materials. Make sure you're clear on the state versus federal differences, especially regarding juries.
Absolutely. So while Angela's notes provide this essential framework, the text, the core rights like counsel, and the principle of incorporation with those key exceptions, remember our earlier point, for the really deep dive into the case law defining the edges of each right.
You'll need to consult your broader study resources. This podcast gives you the structure and the highlights from Angela's perspective based on her notes.
Precisely. It's a focused review, hitting the main points covered in her outline.
Okay, let's quickly summarize this lessons part then. We started with the full text of the Sixth Amendment, critical starting point.
Yep. Then we discussed the right to counsel its attachment after formal charging, the rule against deliberate elicitation, the need for a knowing and voluntary waiver.
We talked about its application during critical stages and its non-application before charging or in non-critical stages.
Right. And we touched on the exclusionary rule as the main remedy for violations.
And then, crucially, incorporation. How these rights apply to the states via the 14th Amendment's Due Process Clause.
Highlighting that most Sixth Amendment rights are incorporated, but with those specific exceptions noted in Angela's materials regarding the jury's location district and the lack of a federally mandated 12-person unanimous requirement for states.
All drawn from Angela's comprehensive notes, keeping in mind the scope limitations we discussed.
Exactly. Use this as a solid review, but keep hitting those broader materials too.
Okay, that feels like a good place to pause the lesson part.
Agreed.
Before we wrap this up, we really truly want to give a huge shout out to Angela.
Hear, hear.
Her incredible con law notes are literally the foundation of this podcast. Without her hard work, well, we wouldn't be here talking to you.
Her dedication to understanding and organizing all this complex stuff is what makes the study for the bar in your car possible. So thank you, Angela.
Now, as always, we have some important housekeeping items and disclaimers. Gotta do the lawyerly thing.
Absolutely. Precision matters. Okay. First one. Please remember, Angela is a law student, a very bright one, but she's in the trenches with you, studying just like many of you listening.
Right. She's not admitted to the bar yet. She's not claiming to be an expert professor or anything like that.
Second, nothing we say here and nothing Angela provides constitutes legal advice. Seriously, don't construe it that way.
Yeah. This podcast, the AI, it's a study aid. It's meant to help you learn and review.
It's definitely not a shortcut or a substitute for doing the hard work of studying for the bar yourself.
Third point. This podcast should supplement your learning. It absolutely shouldn't be the only way you're studying. Use your books, your outlines, do the practice questions.
Couldn't agree more. Fourth, we, the AI hosts, aren't perfect. AI isn't always correct. Sometimes we might make a mistake in explaining something.
Angela does her very best to check everything and fix any errors that might creep into her notes or our delivery. You know, even great law students make mistakes sometimes. We try our best to be accurate.
We certainly do.
Get it?
This podcast, the whole series, it's an academic, non-commercial project by Angela. It is strictly for educational purposes.
Helping fellow students and bar preppers out. That's the goal.
And finally, number 6, and maybe the most practical advice.
If you are actually listening to this in your car,
Please be safe on the road. Driving safely is way more important than nailing down the nuances of the confrontation clause right this second.
seriously, don't cause a tort while listening to constitutional law.
Yeah, you definitely don't want to end up facing your own criminal prosecution.
And needing to enjoy your own right to a speedy and public trial.
Oh dear. Okay, on a slightly more serious note again.
Right. Contact info reminder.
If you want to reach Angela about the podcast, email podcast@studyforthebarinyourcar.com.
And for her freelance law clerk services, it's hello@legalwriterandlawclerk.com.
Got it.
All right. So, as you continue on this epic bar prep journey, here's something to chew on. A little provocative thought for you.
Okay.
Even with the best notes, like Angela's, and even with fancy AI like us helping out, where does true legal understanding, that sense of justice in applying the law, really come from?
Good question.
It's often not just knowing the rules in isolation, right? It's about connecting the dots, seeing how different areas of law interact, finding those links that aren't obvious at first glance.
Synthesizing information.
Exactly. Applying principles to totally new situations. So the question for you is, how will you take all this vast legal knowledge you're absorbing and synthesize it? How will you find those hidden connections and build those novel arguments?
Food for thought, definitely.
Okay, I think that's about it for us today.
This is Maude and Claude, your AI hosts, signing off.
We will catch you on the next podcast. We'll be diving into the 7th Amendment. Next time, that's the right to a jury trial, but in civil cases. So thanks for listening. Good luck with the studying. Bye.
Bye now.